Welcome to Litigation Nation. I'm your host, Jack Sanker, along with my co-host, Danessa Watkins. This is the show where we cover the most important and interesting legal news of the past couple of weeks. Reminder, you can always find us on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. We publish every other week, with the exception of our summer hiatus that we're just coming out of here. Danessa, what do we have up today?
Hey, Jack, good to be back. So I am going to cover a recent opinion out of Texas District Court, which is probably going to go up to the Supreme Court at some point, and we may have new law on whether the 10 Commandments can be posted in public schools.
And I'm going to be talking about what I'll call the PE-ification of law firms, the private equities, attempts to invest directly in the ownership of law firms, something that has been otherwise prohibited or illegal in just about every instance since the last 150, 200 years, and the way in which those rules may be changing and what to expect. All of that and more, here's what you need to know. So we're going to be talking about, during my section, some news from this past week that was released by an investment firm, which I can talk about, and I may have talked about in other episodes, called Burford Capital. Burford Capital is a third-party litigation finance firm. They are the biggest that operates in North America. I think it's the biggest one in the world, and they are one of the few that are publicly traded. Third-party litigation finance, we've talked about on the show quite a bit, but it is the practice by which outside funders can take a financial stake in the outcome of a lawsuit, typically in exchange for upfront capital. So an example of that would be someone wants to sue, or person A wants to sue person B. It's usually companies here, but person A wants to sue person B, but can't afford to pay the hourly fees to a lawyer, can't afford to pay for experts, things like that. The lawyers are prohibited from lending money directly to their own clients under every ethical rule that I'm aware of. And so in that situation, typically the litigant who can't afford to hire an attorney is going to be out of luck. In steps these third-party litigation funders in exchange for lending them money to pursue these cases. They will take a percentage of the outcome of the lawsuit. So they may lend someone some money in exchange for, 10% or 15% or whatever it is that's recovered in the lawsuit, right? That's a very simplistic way of describing it, but that is gives everyone a good sense of what these folks do. There are other lending arrangements too. There's it gets as complicated as you want it to get, but that's by and large what you need to know for purposes of understanding who Burford Capital is. Burford is, I think, has a market capitalization of about $1 billion. They've been in the news for lots of other things. For example, they are attempting to collect on, I think, a $300 million verdict against the State Bank of Argentina, which is its own thing. But Burford's been around for 10 or 15 years. They're an established company, and they're the biggest player in this sandbox. This past week, Burford announced that they are looking to collaborate with law firms, none of which were named, nor would you expect them to be, but looking to collaborate to invest directly into law firms, meaning they want to take an ownership stake of law firms themselves in America. Right away, that is, at the surface level, that's something that's generally not prohibited. And there's a lot of reasons for that, which we'll get into later. But by and large, you can't have non-attorney equity of law firms in the American system. You can't have non-attorney fee sharing in the American system, with few exceptions as well. And there's sort of public policy reasons for that, ethical reasons, and so on. But whatever justification you want to assign to it, that has been the case for as far back as I could find. In preparation for the story, I was kind of looking into some of the really, really, really old ethical treatises that were published. And so I was able to find back as far as 1820, where they were discussing the issues with having non-attorney equity and non-attorney fee sharing in firms, things like that. So most states, at least with few exceptions in I think Virginia, Utah, most recently in Arizona, but in most states, it's just this type of thing is just not allowed. You can't do it. Firms have to be owned by lawyers. Fees generated from providing legal services must be shared only among lawyers. They can't be shared among anyone else, and that includes, by the way, employees of the firm. So they're increasingly we see things like non-attorney CEOs or non-attorney executives at law firms. Those folks can't have equity in the law firm. They can be paid a salary. They can have bonus structures and things like that, but they can't literally own a part of the profit or the revenue that comes into the firm. They can't own equity stakes in the firm. Burford wants to get involved. Burford wants to buy into law firms, and in this sense, Burford is operating as essentially like a private equity firm here. In their announcement from this week, Burford alludes to the fact that law firms may be gun shy about working directly with PE firms, so they might be a little more comfortable working with a litigation funder, just because of the proximity to the practice of law that litigation funding has, as opposed to a normal private equity firm or something along those lines. But they are effectively, if they do this, they will be acting as a private equity company. So how are they going to do it? Why? Well, actually, you know what? I'll back up from that for a moment. It's reasonable to ask, if you're listening to this, why should anyone outside of investors or law firm owners care who owns law firms in America? Why is this? Why? Who cares about this, right? It seems at surface level just kind of protectionist. It seems at surface level just a way for lawyers to protect their own margins and to keep outside investors out. And all of that is like a fair critique and probably at least a little bit true. However, there's a lot of other reasons that are kind of below the surface. For example, in some of the treatises that I was looking back to of, from 180-ish years ago or whatever, they point out the natural conflicts that would arise in situations like this, where outside investors who are involved with the firm, they're not bound by the ethical canon. They're not bound by the ethical rules that lawyers are.
That was the first thing that came to mind for me. Yeah.
Yeah, they're not bound by those things. So, they cannot be punished by the state ethics board. They cannot be disciplined by your state Supreme Court for violating different ethical issues that we all have to constantly be worrying about. It's kind of our
As big
mental.
as like money coming in and what type of account can you put client money in, and you can't commingle it, and like just the most basic stuff.
Yeah. It's our like mental overhead for practicing law is these ethical compliance things, that make it more complicated to run a law firm than it is to run other types of businesses. And in certain instances makes it less can make it less profitable. Not that lawyers don't make a lot of money, don't get me wrong here, but if you're just an outside investor who buys into something and all you care about is a return on your investment, that's it. And if you have a stake in the company, or maybe if you have a controlling stake in the company, right, you can leverage that through the fact that you own it to try to influence business practices towards, getting greater returns, which can be in conflict with these ethics rules. If you have a client that, um, and again, not that law firms aren't businesses, and if we have non-paying clients, we don't like that. If we have, if there's a business aspect of representing someone that is not great for us, we try to get away from that type of thing. We're not working for free for the most part, outside of some pro bono work. However, if I have a client who for one reason or another, is difficult to deal with financially, I can't just drop them. It's not that simple. And any lawyer who's been in this position, by the way, knows exactly what I'm talking about. You kind of have to let them go in such a way that won't prejudice their rights as a litigant or as a client, which can mean you stick in the case for months while you try to.
Yeah, if it's active litigation, you need court approval.
Yeah, if it's active litigation, you need court approval. But even beyond that, if it's which means, by the way, folks, you have to file a motion for leave to withdraw and ask a judge if you can terminate your relationship with the client, and the judge can say no. And I've had this happen to me before, and I've had the judge say no because my client was indigent, because my client could not pay, because effectively the court's saying, well, if they can't have you, then they're not going to hire another lawyer and they're going to be screwed. And so you're going to have to figure this out among yourselves. In the meantime, you have to proceed with the litigation, you have to proceed with representing them, and you have to do so in accordance with your ethical rules, which means you have to do a good job. Um, so all these things, you can imagine would come into conflict with someone who's just purely interested in return on investment, right? That's kind of an easy one to point out. Um,
Thinking too, and I don't know if you're going to get to this, but discovery. So, how many times have you had a case where, shoot, why did you send that email, client? We have to turn that over. Like, I have zero basis to not turn this over. It hurts our case, but we got to deal with it. I could see that being an issue if you're not bound by those ethical obligations and you just dollar interest in the case outcome.
Yeah, and I mean, there's a million things you could think about hypothetically too. Like if we open up our doors to outside investors and we were allowed to do so, and what if, someone buys a controlling stake in Amundsen Davis and then says, you know what, guys, we actually own this other company over here, and we want you to sue all their competitors. We want to weaponize your abilities as attorneys to just start, increasing our market share in other things that we're invested in.
You know what the White House just did?
Uh,
Sorry, it was unflattering. Sorry, go. Okay, move on.
yes, yes. But like say Amazon buys a controlling stake in Amundsen Davis, and they says, "Hey, you know what, guys? We want you to just start suing, I don't know, Apple or whatever, all those things." And now they're directing lawsuits that could be frivolous or not based on like good faith claims or whatever, just solely to deplete the resources of their business competitors. It also
Could be
creates conflicts. Yeah, conflicts aspects as well. If PE firms are often invested in multiple enterprises, not just one at a time, and you could structure this however you want, I suppose, but now all of a sudden you can represent some people and not others based on the ownership structure of the PE firm. It's just like it's a Pandora's box of ethical concerns. Uh, and it also encourages some pretty nasty behavior on behalf of the individual attorneys, who may be prioritizing the shareholder return above their ethical obligations to the clients and all those things. Which again, let's not be naive. I mean, there is an aspect of it's a for-profit business. There's an aspect of this where you must make money to survive. Um, so but it's strictly confined within the each of your state's ethical rules, and then on top of that, whatever jurisdiction you're practicing in, the local courts regulate this stuff, and then on top of that, state statutes, federal statutes, and so on. So you don't have a lot of leeway to just do what you want to do just to make a profit here, in the way that you can in say finance or whatever. Um, so that's one of the reasons why you should care about this if you're just a normal person who's listening to this. The other thing I would say is, you know, and stay with me on this. Uh, there are about 70 million lawsuits filed in America every year, of a country of 320 million people. And so this is business disputes, payment disputes, landlord-tenant issues, car accidents, marriage dissolutions, or custody lawsuits for children, workplace safety, wage and hours, school and education, race, gender, sexual orientation, disability, privacy, intellectual property, and so on, right? And I'm talking about private lawsuits that are filed in this country, 70 something million of them every year. In America every year, there's about 10 million arrests that take place. Like 10 million people get arrested every year for violating crimes. Um, and why does that matter to this conversation? I would argue private lawsuits, private litigation is law enforcement, and it is actually an extremely common, and much more common form of law enforcement in the literal sense of like enforcing the law.
Keeping people within the bounds.
Yeah, well, I mean, yeah, I mean, there's most laws are on the books and are left up to private actors to enforce, is what I'm getting at.
Mm-hmm.
Police enforce a limited set of laws. Regulators promulgate laws. They draft them, but regulators don't arrest people or whatever. Quite a bit of law enforcement is done by private actors, litigants who are enforcing their rights, protecting their rights, trying to get back something they believe was wrongfully taken from them, to do one thing or another based on rights that are either granted to them by state or federal statute, the constitutions, or our system of common law. So in that context, 70 million losses versus 10 million arrests. And there's all sorts of other I understand, criminal law enforcement is not just arrests. I understand. There's a lot more to it than that. My point is that private lawsuits are a huge part of enforcing the law in this country and how your day-to-day life is governed. If law enforcement is a form of governance, which it is, then so is private lawsuits. So if you're worried about that type of thing, and if you're worried about who gets to decide how and when laws are enforced in this country, I mean, you should care a lot about, your local policing and how that works and rules around policing and criminal statutes and everything else. You should also care about the statutes that authorize these types of lawsuits. You should care a lot about the people that are deciding and the motives of the people that are getting involved in private litigation. Which is why we have these ethical rules to begin with when it comes to attorneys, because even prosecuting private lawsuits, suing someone for money or whatever, you are considered an officer of the court as an attorney, and with that comes all these different responsibilities and everything else. And if you outsource that to an unaccountable, for-profit organization, now you have much less control over that system. And I think that is, I'm not saying that I'm not being doomy and gloomy over this, but it's enough. I hope I made the point that you have a stake in this, and it should matter that who it is that's going to decide the ebbs and flows of private lawsuits in this country. It does affect, an everyday person is kind of what I'm getting at.
So the three, I think you mentioned 3 states where they do allow for this in some form. There must obviously be some sort of checks and balances or limitations on how that works.
Well, not in Arizona, but Arizona's the Wild West right now, and that's a whole nother episode someday. But Arizona in 2021 changed the rules around this stuff, and they also changed the rules around fee sharing. So the one thing you can do in Arizona, for example, is if you want to refer someone to a law firm for like car accident, right? You can ask for a referral fee from the lawyer. Very interesting in Arizona that if you are a physician who is, someone walks into your clinic and it's like, I just got run over by a bus, you as a physician can take a referral fee on that. Yeah. So like you can see like it's
That's messy.
Oh yeah.
And then that's the physician that's going to be testifying on your behalf as well.
Yep,
Yeah. Oh yeah. I see where that's going.
And the physician is going to be in charge of, prescribing you whatever treatment you need and jacking up the medical bills. If anyone has worked in injury stuff, jacking up the medical bills to the point where, getting you a bunch of treatment you don't need because they have a financial stake in it. And so on. Like you can really entertain yourself thinking about where this goes. But I'll set those 3 states.
Sorry, now I'm like stuck on that. I'm like, did we not learn from Big Pharma? Like, anyways, go.
Yep. Now, proponents of this type of thing, I mean, they have arguments for it other than just, we want to get private shareholders access to this market. I mean, they correctly will argue that this type of arrangement can allow for greater access to attorneys by driving down costs. For example, if someone it can be funded by private investors, then they can maybe they don't have to charge so much from the individual clients. It also would, at least according to the proponents of this type of thing, increase competition. It's hard as an attorney to start a law firm because you what do you go to a bank? You have options to get a small, like you can get a line of credit or a loan from a bank. And that's about it. Whereas if you have another business idea and you want to start a business or whatever, you can go to friends and family, business contacts, institutionalized investors and say, I want to start this business. I need operating capital. If I give you 5% equity, would you give me some startup money? Right? Everyone else can do that. Lawyers can't. And so it arguably stifles competition. Entrenched actors have a lot more power in local markets in particular because of this. It's very difficult to start from the ground up. People do it all the time, but it's difficult to do so. Um, so those are kind of both sides of the argument here as to why this should or shouldn't be the case. But what matters is it has not been the case for as far back as I could look in American history. Um, and so how do investors such as Burford Capital and you would imagine PE firms that want to get involved, how are they planning to get around this? Um, Burford plans on doing so on what's called a management service organization, MSO. And this is a model that's been commonplace in the healthcare services market. And it's kind of where it's become kind of famous now, where PE firms can acquire health practices, which are regulated kind of similarly, but not exactly, but similar restrictions on where money can go and who can own what and everything else. And what they'll do effectively is create an MSO, management services organization, that attaches itself to like the law firm, and can be paid a subscription fee or however you want to structure it, in return for providing management services. So, accounting, finance, management, document, et cetera, things like that. At surface doesn't sound any different than just outsourcing this stuff to an accounting firm. Like if you own a law firm, you can hire an accounting firm to run your books for you. There's nothing wrong with that. But the way that these MSOs are different, at least in healthcare instances, they take an ownership stake in the healthcare company, um, and in doing so, they basically stuff the equity holders of the healthcare firm full of money, in exchange for selling some of their equity to the MSO, who then owns the practice. And at that point, they have an ownership stake in the practice. However, it's organized, whether it's a board or something else, they also get to start making management decisions about how the company gets run. So you hear horror stories about, um, uh, hospitals that get acquired by PE firms and they cut the staff 30%, service goes way down and all this stuff because the investors just want the return. And they're like, hey, if we can squeeze the staff a little more and, prop the margins up, that's more for us. Um, so does this seem like it might be legal? Well, there is this MSO thing that Burford wants to try out. There is a recent decision in Texas which discusses um, the potential for an MSO law firm model and effectively says, yeah, why not? The attorneys are still going to be regulated within these ethical confines. They still are going to have to be, um, you know,
Accountable.
yeah, maintain privilege with the client and confidentiality and all of those things. And you have to structure it in such a way as to make sure that the MSOs aren't getting a peek behind the curtain as to legal decision making and so on. But if your compensation, either as a partial owner of the MSO, partial owner of the law firm, or as an attorney at the law firm whose compensation is now tied up in both of these structures, one way or the other, um, you're going to be asking these people to act sometimes in their own against their own interests by um, strictly adhering to the ethical rules at the expense of, say, profit or at the expense of investor return or all those things, which happens in law firms all the time because we have to because of the ethical rules already. But you're adding the added pressure of people that are not bound by the ethical rules to that consideration. And, in my opinion, everyone is movable at some point or another. And attorneys that, maybe weren't likely to behave unethically before could be nudged towards that if they are tied up in one of these, organizations. Um,
Primarily for plaintiffs' firms, or is the model applicable to defense firms too?
I think it's applicable to both. I mean,
Okay.
third-party litigation funding is more common on the plaintiff side of thing because it's
If you
just
get a payout.
yeah, it's just a different. It's just where it kind of more shows up. But there's absolutely nothing preventing it from, from attaching itself to a billable hour defense firm and effectively taking a chunk of every hour that gets billed.
Right.
That's how it will get set up.
Right.
Um, and so Burford doesn't have a partner for this yet, but they announced that they're looking for partners to do this with. They're announced that they want to do this with firms. In Arizona, where the rules have been much relaxed on this type of thing, like I mentioned before, there have been instances of PE firms basically buying into law firms and just saying we own you now. But now we're going to pay you, your salary and everything else, but we literally own the firm. Um, I think that debate is still ongoing as to, whether it was a mistake in Arizona to do this. Um, I think it's early. People are testing the waters on that structure, as I understand it now. I'm not aware of any like huge glaring, like really, really abusive setup that has, resulted in people getting screwed or whatever. But it's like it's right there. You could do it. You could see it. You could envision it
Right.
happening. Um, and if this type of thing catches off in, say, Texas next, and if it catches off elsewhere, I mean, it's going to be, the floodgates will open, the money will pour in, the margins in law practice are higher than they are for most other types of businesses, right? You can make a higher profit margin in law practice than you can running a supermarket, for example. Uh, so the PE firms are going to want that. And if you are, by the way, if you're an owner of a law firm, partial owner of a law firm, or whatever, and you want, an exit strategy for your ownership stake, you'd love to be able to sell it to a PE firm, and retire, or something like that, right? Uh, so if you get rid of these rules, if you just tomorrow we snapped our fingers and all these prohibitions in all 50 states were gone, I think you would just see firms getting gobbled up
Right.
immediately, and because everyone will want in at that point. Money wants in, and the money would have been trying to get in for the last 150 years, and just has not been able to. So that's why it's a little, it's like tweaking the law here and changing things there. There is like a pent up demand for this type of investment opportunity that is just going to be massive. And legal services industry in the United States is billions and billions of dollars. People are going to want to wet their beak with that. So this announcement by Burford that they're openly looking to do this and they're going to test out this MSO model as soon as they get someone who's willing to do it, which someone will, because the reasons I mentioned, I'm sure there's a lot of folks that are just looking for a buyout. Um,
Mhm.
it could fundamentally change the way that the law is, enforced. I'll stick to that thesis of private lawsuits being law enforcement. And I'm not here to like, to be shrill about private equity firms ruin everything and so on. You see those takes, or whatever. But there's a lot of horror stories about PE firms acquiring companies and running them into the ground. You're like that happens because they extract whatever value they can and then they toss it aside. I mean, I remember when I was a kid. Um, I remember it was a big deal in the. I wasn't a kid. I was a young person, I suppose. But do you remember the 2012 election, Mitt Romney, who worked for Bain Capital, a PE firm, and was
Mhm.
famously, Bain Capital was, I believe, the PE firm that bought out Toys R Us and like stripped it down, loaded it up with debt, and then basically paid themselves management fees. And if you're listening, Bain Capital, I'm saying all this hypothetical. I've not fact checked this. I'm speculating. This is all a joke. But it eventually resulted in Toys R Us going bankrupt, while Bain Capital made money off their investment. So there's a lot of horror stories about PE investment, private industry. Whether that would happen in law firms or not, it's hard to say. But the point is this were this to catch on, and it might catch on, would be a pretty seismic change in the way that law firms are run and the incentive structures for pursuing litigation and filing claims and suing people or not suing people based on all these things. And it's going to be very interesting to see how the different states react to this. I think it's going to be a state by state thing, and whether they can resist the tsunami of cash that will come pouring in if it gets cracked open.
Mm-hmm. Yeah, super interesting. Yeah, and there's definitely a lot of layers to it. I can't imagine it's going to be something that catches like wildfire. I think obviously each state is going to have different concerns about it, but I wonder. So, of course, this is me as a defense attorney. I feel like it's too easy to file a lawsuit, and you drag people through litigation on meritless things, and it's just a drain on.
70 million,
I'm sorry.
70 million lawsuits.
Right. But so yeah, what I'm interested in is whether this would improve the quality of the lawsuits that get filed and, cut out some of the BS ones, or if it would do the opposite and we'd have more litigation filed because, people who couldn't previously afford it or something. I don't know.
I think you're going to see it improve. I think you're going to see more.
Yeah.
I mean, this because one of the reasons why frivolous lawsuits get, truly frivolous lawsuits aren't brought is because the cost of doing it. And it's not a lot of money to file a complaint. Filing a complaint is usually a couple $100. So anyone can do that, right? But everything else associated with it, if you go far enough, discovery, et cetera, if you're paying for a lawyer, if you're pro se, it's cheaper, but it's your time that you're using there. And these bigger firms could talk themselves into, or these bigger, like these investment firms could talk themselves into, let's just make every complaint AI generated. Let's just automate discovery. Let's just ruthlessly enforce efficiency and KPI metrics and all of those things, and drive the cost down, which people will say is good for access. It allows people to get lawyers more cheaply. It also means more litigation. It means more lawsuits are filed. So, for every 70 million of these lawsuits, some person is served with a process summons and a complaint and says you've been named in a lawsuit for, and that's not a great feeling, I would imagine. So, yeah, I mean, I think you would see, if anything, more litigation.
Well, let's hope that maybe Arizona will be the guinea pig and Illinois will hold off for a while and see how that plays out.
Yeah. Like I said, that's a whole nother can of worms. Maybe we'll cover that in the future, but that's
Yeah.
This will be interesting. We'll circle back if Burford ever announces a partnership and find someone to do this with, and we'll let everyone know.
I think the separation of church and state is one of those, areas that we've just known exists, and it's a bedrock principle of our democracy, yada, yada, yada. Well, that's potentially about to be flipped on its head. We now have a third state in the last, I think it's year and a half, that has tried to pass or has actually enacted bills that would not just allow, but require publishing the 10 Commandments in public schools. Now, the latest one has come out of Texas. So on June 20th of 2025, the governor, Greg Abbott, signed Senate Bill 10, which provides that every public elementary and secondary school in the state shall display in a conspicuous place in each classroom of the school a durable poster or framed copy of the 10 Commandments.
Shall display. Very interesting.
Shall display.
Not is permitted to display.
No, shall display. And I mean, the nuances of this bill are extensive, almost to the point of why wouldn't you dial back a little bit, and maybe give a chance for this to go through? But no, it's pretty extensive. So They provide the size of the poster has to be at least 16 inches by 20 inches in size, in a size and typeface that is legible to a person with average vision from anywhere in the classroom, have to be up permanently all year round in every single classroom to account for example, high school students who may change rooms throughout the day.
Boy.
And they specify the exact version of the 10 Commandments that have to be published, which I guess admittedly, I didn't realize that there were different iterations of it. So that tells you all you need to know about me.
I was a religious studies major in college I was a history major as well. So there's like the competing translations of different
Yes, yeah.
parts of the Old Testament is like a very nerdy thing that I could talk about, but I won't.
Well, it's laid out in this court case, pretty detailed. So it's probably a refresher for you. But yeah, so this was, and it's full from as early as kindergarten all the way through high school. So any public school has to display this. And it was set to go into effect on September 1st of this year. But within, let's see, about 2 weeks of the bill being passed, there was a lawsuit filed in federal district court by a number of parents on behalf of their children, suing various school districts, seeking declaratory and injunctive relief. Now, their arguments here are that their claims actually are brought under the Free Exercise Clause and the First Amendment. So under the First Amendment, they're saying that this is an obvious rule that favors religious scripture. It's adopting an official position on religious matters, violating the Establishment Clause's prohibition against the government taking sides on theological doctrine. Government may not officially prefer one religious denomination over another. And then under the First Amendment, violates the provision that Congress shall make no law prohibiting the free exercise of religion.
I was going to ask, is there any, it's just the Ten Commandments. There's no even like, and let's put the Quran up and it's just 10 Commandments.
Just the 10 Commandments and just this specific version of them. So the plaintiffs in this case are from all different religious backgrounds, including certain Jewish and Catholics that are saying these are not the 10 Commandments that we practice. So obviously they brought some very interesting arguments in their complaint, and the judge who's overseeing this, let me give him some credit here. This is out of the Western District of Texas, and it's Judge Fred Beery, Bierry. He wrote a 55-page legal poetry opinion in response to motions to dismiss this case. And I say legal poetry because, and Jack, you would appreciate this, he literally goes through like the history of
let's go. I got to read this.
Yeah, of separating, state and religion. And on one page, I just marked a couple of pages that I was like, wow. On one page, he says, government and religion joining hands. One picture from the modern era speaks silently and poignantly of the danger of majoritarian government and religion joining hands. Excuse me. And then it's a picture of Adolf Hitler greeting a bishop at one of the rallies in 1934. Goes through American history, specifically dating back as far as a speech that Ulysses S. Grant gave in 1875, where he says, quote, "Leave the matter of religion to the family altar, the church, and the private school, supported entirely by private contribution. Keep the church and state forever separate." Then fast forward to 1963, Reverend Billy Graham gave this quote, "80% of the American people want Bible readings and prayer in the schools. Why should the majority be so severely penalized by the protests of a handful? And then the judge puts in parentheses under it, with all due respect, Reverend Graham, it's the 20% who are protected by the Bill of Rights.
Correct. That's good.
Yep. He goes into, so the test for the Establishment Clause in particular, it's actually in flux right now. So the former test, which came down 45 years ago when the Supreme Court determined that this is Stone v. Graham. It was a 5-4 opinion, and they adopted the Lemon test, where you look to whether a statute has a secular purpose, whether the statute could or could not promote or restrict religious beliefs or practices, and then whether it fosters excessive church-state entanglement, which, how complex of an inquiry is that? But that Lemon test just recently was rejected by our current Supreme Court. And it now looks like we're going to start going back to the, what historically has been, yeah, I know.
Oh.
That. So instead of
That's what they are relying
what's
on.
that?
We covered that, I think, in detail
Mhm.
on a prior episode, which I will check with my producer and let you all know at the end of this.
Yeah, so they're throwing out these like balancing interests, and now judges are instructed to consider history and the understanding of the founding fathers when dealing with the Establishment Clause. So the now that decision was not specific to a Ten Commandments case, so there is some question as to whether the lower district courts, whether they need to follow precedent from however long ago, which says clearly the Ten Commandments can not be published in a public school. But now there's this question where, and I think that's why these states are now 3 of them have passed these bills, because they're like, let's test the waters.
Yeah.
Maybe we can show that historically the founding fathers didn't intend for the Establishment Clause to be read this way, and maybe they wanted to leave it up to the states to make decisions. So that's why I think this judge took the time to go back through history and actually lay that foundation of, let's see how this has been debated over the years. And
in preparation for the Supreme Court,
yeah, for sure,
applying their nonsense history and tradition test to the ruling.
Right. So the other 2 states that have recently dealt with this issue, one of them was Louisiana, and that one, it was almost a similar statute to what Texas tried to pass. But the federal district court in Louisiana said, this violates the First Amendment. That went up to the federal appellate court there, which is the Fifth Circuit, which is known for being one of the more conservative circuits. And they upheld the injunction on requiring schools to post the Ten Commandments. So this district judge in Texas kind of followed that lead and said, actually, I think he pulled from one of the historical experts that was presented in that case, who said, if we look back at what was going on in the founding, there were not public schools.
Right.
So,
yeah, that's a good point.
so this whole argument that that the founding fathers would have allowed this. Well, we can't say that because there weren't even public schools at the time. And then when finally we have a public school and there was an attempt to make this requirement that the Ten Commandments be posted, that was North Dakota in 1927. And the court immediately struck it down under the Establishment Clause. So, it wasn't that long, less than 100 years ago was the first time that this issue arose, and it was a no questions asked. So then one part that I found really interesting about this decision is we have to, and we've talked about this before too with the First Amendment, you have to look at the cohort, right? Like what age group are we talking about? Because different rules may apply to different ages, especially when it comes to these issues of freedom of speech and freedom of religion. And this judge looked at the coercion tactics that can happen, especially when you're talking about like elementary school kids, and you're talking about peer pressure. And maybe at home, parents are saying, we follow this religion or we don't follow a religion and we don't believe in religion. And yet they come to school and they're forced to, look at this poster every day. Questions may come up during class. Well, what does that line mean, teacher? And, it's just these kids are
Because religious instruction is,
yeah. I mean, the kids are sponges at this age, and they're more likely to be afraid to go against the norm. So, and I mean, you're in school, but the majority of your day, versus in your home. So,
yeah, I mean, I'm sure that the lawsuit in particular was brought on, there's the free exercise element of it, and then there's the establishment clause element of it. So it's the individual rights of American citizens to have the right to freely exercise their religion, which may include not being instructed by another religion. In fact, I think that's most religions. That's kind of the whole deal. And so, if you send your, Jewish or Muslim or Sikh child to school, they should not be instructed on, I would guess, some type of weird Protestantism, but yeah, okay. Anyways, um, yeah, and then there's the Establishment Clause, which, directly we think says the government shall establish no specific faith as, an official faith of the United States.
right.
Yeah.
Yeah. So, I mean, that's where the coercion comes in, right? So, so the attorneys for these school districts, they tried to say, well, no, look, we're looking at the history. So, Texas has a history of, I don't even, honestly, I can't even repeat their documents because it just didn't stick in my head. But,
I hope the
okay.
listeners feel me rolling my eyes through the audio.
Well, so yeah, so they're trying to say, look, this isn't about religion, this isn't about coercion. We're just trying to appreciate the traditions of our great state. And the judge then goes on for I think 3 pages quoting the legislative hearings on this where you're introducing the bill and discussing the bill, so before it got passed. And he quotes, so in support of Senate Bill 10, the lieutenant governor stated, quote, in every classroom in Texas, students are going to see the 10 commandments and they are going to know about God, end quote. Then in the next sentence, supervisor and author said, we want every kid, kindergarten through 12, every day in every classroom they sit in to look on the wall and read those words that God says, because we want them to understand how important those statements of God, those rules of God are, that they see them in their classroom every day of their public education. I mean, just like these statements, it's like you're literally talking about the one God and that the students should appreciate the one. Like, it blows my mind that they even tried to make that argument knowing the legislative history of this bill.
Yeah, I mean, yeah. And this argument's like as old as you can as you want to make it. I mean, it's people have been bickering about this for forever. The founding fathers, they were religious, or at least, the ones that you want to pick out were religious. Therefore, they obviously founded this nation as a, religious nation in their image of their faith in particular, or whatever. People have been saying that for, I mean, I remember that you cover this like your first year of law school, and it's like, yeah, you can't do this. I would note that many of the founders would be rolling in their graves if they knew that Texas was publishing the King James version of the Ten Commandments, which I did check. And if
Oh, you got it? Okay, yeah.
yeah, this Anglican nonsense is being forced on our young American children, get out of here with this.
Right.
Um,
So funny, yeah. So then, yeah, he just concludes with, it's just saying like, most people want their matters of faith, like they want to be left alone when it comes to what their religious beliefs are. Um, and he raises a good point. He says, even though the Ten Commandments would not be affirmatively taught, the captive audience of students likely would have questions, which teachers would feel compelled to answer. That is what they do. Teenage boys, being the curious, hormonally driven creatures they are, might ask, Mrs. Walker, I know about lying and I love my parents, but how do I do adultery? Truly an awkward moment for overworked and underpaid educators who already have to deal with sex education issues. And then he says, here's some other ways we can try to like publish like alternatives to religious rancor, essentially, and then gives like precepts of Buddhism: abstain from killing, stealing, and engaging in sexual misconduct, or do unto others as you would have them do unto you. Be kind, be respectful. Like just showing like there are ways to teach kids how to be good humans without crossing the line into religious territory. So I thought, I mean, if anyone's interested in this stuff, this opinion that came down yesterday, so August 20th of 2025 in the Western District of Texas, is truly legal poetry. It's a history lesson. It's just a great work of art in that he knew this was going to be, something that's talked about, and the judge took the time to really put out there, what he thinks ultimately the Supreme Court should be considering when it decides this issue.
Yeah, I mean, I'm willing to bet if you did a Venn diagram of people who, want this bill and want the Ten Commandments in the classroom, one circle, then the other circle is people who are, scared to death of um, uh, people implementing Sharia law. And like that's like the boogeyman in politics or whatever. Sharia law. If you the Venn diagram of those two things are is just one circle.
Yep. Yep. Um, so not surprisingly, within 24 hours, this was appealed. Um, so we'll see what the
Fifth Circuit.
fifth. Oh, okay. So they had to follow the Fifth Circuit's decision in the Louisiana case. Okay, that makes sense why they relied on it so heavily. Um, so yeah, I mean, at some point this is gonna go up, I would say, and there's a lot of talk about, again, why would these states be challenging what's been such a clear ruling for decades, and it's pretty obvious. Look at the court we have right now and the precedent that's being overturned session after session. So if there was ever a time to challenge what we've always known and accepted, this is, I guess, the time to do it. So I guess
Yeah,
it remains to be seen.
it's interesting. I mean, we're not like a court watching show. We don't like do Supreme Court predictions. That said, I don't expect that this would survive at at SCOTUS, even with its political leanings and everything else. Because it does seem, I mean, it strikes me as such a slam dunk. Um, uh, that's why I asked at the beginning if there were any other religious things that were also being included in this, because if I remember, one of the ways that, if you're going to display the Ten Commandments, then you can like, if you're also displaying, I don't know, some equal representation of world religions or something like that, then at least you could argue it's like being neutrally presented without favoritism towards one side or the other. Um, so you might get a ruling that like relaxes those standards. I mean, the thing is, even if the court rules against this, it could still say, it could still weaken the free exercise jurisprudence by applying its history and tradition test.
Right.
And which I honestly would expect is the point of this type of legislation, which the folks that are involved in this from Texas ought to know that the statute itself is going to be unconstitutional. However, they in that ruling they could pry open the rules around other things that they would want to do, and which would give them leeway to do something different, just by virtue of the Supreme Court saying, "Hey, we're going to overturn the test that we apply to this type of thing. We're going to still rule that it's unconstitutional, but for these other reasons." And then Texas gets to do whatever it wants to do based on that.
Yeah, that's a good point. And I wouldn't be completely surprised if it did have something to do with the like the location, the government owned location of where religion can be displayed, I guess. Because I did find there was a concurring opinion by Justice Breyer in a was it Ten Commandments public school case that was up about 10 years ago. And he did make mention that the display of the Ten Commandments in public schools must clear a higher legal bar, giving the impressionability of the young. So that may be what, they're trying to do. Maybe in fact, they're not or they knew, that this was going to be struck down, but they're actually trying to have more ability to push religious ideology in other public spaces.
For sure.
This was just such an extreme that I think, like you said, like maybe it'll cause the judges to lessen the rules of the Establishment Clause, I guess, a little bit. But apparently it's these sort of things are happening across the country. So I was just curious of what, if anything, was happening in Illinois. And I did find a recent situation in Jefferson County, Illinois, from July of this year, where a Ten Commandments monument was displayed on the lawn of the county courthouse.
They keep doing this crap, man. I'm not besmirching anyone who wants to be, religion or not, whatever. It's just that issue in particular, the Ten Commandments on the steps of the courthouse has
Yeah,
been litigated into the ground in this
right,
country. There's many, many, many cases of this.
right.
And so if you're doing it, you either you were born yesterday and didn't know anything about it, or you're deliberately trying to provoke a response, and that's the frustrating thing is this is settled law,
Mhm.
and I guess until it's not.
Right. Well, I mean, yeah, and that one in particular was a little bit silly and seemed like a waste of potentially taxpayer money because, of
Right.
course, it was a lawsuit immediately, and then the county within days said, "All right, we're going to remove it," and then they moved it to a church location instead. So but again, I think this is it's one of those times where what we think are the bedrock principles and what we think is the sound law of the Constitution and interpretation of the Constitution is just being challenged, and the needle's getting pushed. So it's an interesting / scary time. But
It will be, yeah. Again, not to get, I'm not in the market of predictions for this type of thing, but I would suspect that Supreme Court, if they take it, and they may not, they might just say, might deny cert and just say, we're going to stick with the lower court's ruling. But if they did, it would be for the opportunity to do away with some of the more strenuous First Amendment jurisprudence as it relates to this type of thing, while still finding this underlying statute is unconstitutional. That's how I would expect it to go.
mhm, mhm. Yep. Okay, well, that is our show. Thank you for tuning in. You can catch us hopefully every 2 weeks now that we're getting back into this. We'll get running again here, but Litigation Nation is on Apple, Spotify, YouTube, wherever you get your podcast. Thanks for tuning in. We'll see you next time.